of major proportions. So thank you for your patience. I can't wait for these things to come back. It's a little more person to person and face to face than it is today. Let me read the obligatory conflict statement. Members of the subcommittee are hereby advised of their duty under the State Ethics in Government Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this subcommittee with respect to which there is a conflict of interest or an appearance of conflict. So does anyone, their knowledge at this point, have a conflict? Actual or incipient? If not, we'll move forward. This is going to be primarily a working meeting. You'll see that when we get down the agenda a little bit. Our assessment areas have remained the same over time. Are there any suggestions for any enhancements or deletions from the areas of assessment at this point? Hearing none. Input from stakeholders. There are no new reports that I'm aware of. If anyone with an assignment for talking to stakeholders has something to add at this point, feel free to go ahead and present that. Is there anyone? If not, I'd like to ask Savannah to give us a report on the interim results of the Securely survey. She had a little surprise for everybody that she added to the agenda, and which I thought was really interesting reading those comments. So Savannah, why don't you take it away?
So it sounds like from our discussion just before we formally started our meeting that everybody took a look at these survey responses that we got so far. As you know, we started by sending the survey out to the state bar counselors first as just a little test group. And out of the 60 counselors, 33 responded. So that's a pretty good turnout. And then we sent it to our stakeholders. And I got confirmation from 3 of them yesterday that they had, in fact, sent this out to their membership, but it wasn't until yesterday. So I think we're going to see these numbers really start to climb like it did even today. We've got in the 90s now. But it's pretty interesting. We've got lawyers of, all different practice areas and all different stages in their careers. And, most people, 90% of lawyers that responded to the survey have used or have wanted to use secured leave. For the most part, it's vacation time, but we've also got births and adoptions of children, or, marriages, reunions, or CLEs. Those are the big ones. And then I think the most important kind of preview area for anyone else that would be tuning in and not looking at the results is that another 90% of the lawyers that took this survey said that taking secured leave improved their mental health. And we got some valuable comments to consider. One of my major takeaways from reading the comments is that people really like to get away and recharge, and knowing something is not going to get put on at least their state court calendar helps them. But another takeaway was they would really like for us to consider in our discussions changing the advance notice requirement, which we know is 90 days right now. The submission procedure, people seemed like that is either confusing or really cumbersome if you've got a lot of cases pending. The calendar week requirement that we've discussed in another meeting already, that can be kind of difficult if you want to take a long weekend, and then the number of secured leave periods. So that's the kind of preview I would want to share. That other people, haven't been particularly successful in obtaining secured leave from a federal court, because they just didn't think that there is no process for doing that. But within the Industrial Commission, my takeaway is that they try and do their best to honor an attorney's secured leave request, although it's not guaranteed.
Very good. Are there any questions of Savannah at this time?
Yes, the one thing that
Savannah,
Gordon, the one thing that struck me, Walter, is that we have this survey and and the question about what aspects of the rule should be changed, if any, and 13 people skipped that. I just find that a little humorous. What's the point of the survey unless you're going to answer that question?
Yeah. Well, true. Yeah, that other places they put in how much they enjoy it, and some have advocated for enlarging the period, but in other sections of the comments. So I don't know. I think we'll have a lot more responses than we have at present. Although we're working on almost 100 responses at this point. But we're gonna put Savannah on these the folks who are ahead of these affinity groups and get a little more love back from them in terms of responses, I hope. But it is Walter, instead of many of them are commenting indirectly on what they like and what's cumbersome. So anyhow, we'll have to read the tea leaves, but that's a very appropriate observation. Anyone else want to comment at this point on the survey or ask Savannah any questions or express any concerns about what we've got? We're gunning to have all the survey responses in before our July meeting. Most of you know, in order to make the meeting in Asheville work, there are virtually no subcommittees that will be meeting that during that week. There's just not enough space to accommodate it and time to accommodate it. So what we're going to try to do is sometime after the weekend of the 4th, convene again. We should have the survey results, some of the data crunched and available. That will be our last brainstorming, purely brainstorming meeting before we start the process of formatting and writing our report. If we've gotten that far, we're not going to sacrifice quality for the sake of expediency, but we are still on that course. Anything else on the survey? All right. Hearing nothing at this point, then we are going to.
Hey, Gordon, can I go? I'm sorry, I was slow on the response there. One thing that I thought was very positive, because we had a lot of discussion about concern over abuse of secure leave, and while there was some indication that it was overwhelmingly never any, 90% had never seen any abuse of the system. So I think that's an encouraging sign that this abuse issue is something that, while we don't want to forget about, I don't know that we need to make that a driver of any decisions.
That is correct. And I know that there was a lot of commentary on that and a lot of concern about having the concern for abuse driving the narrative at our last meeting. Many of you spoke to that issue, and I think collectively we thought, well, that's right, we need to move on and design it for what it's intended to do, and deal with anything that comes up from a few who might practice an abuse at one time or another, and what would happen. You know, the grievance options, the professionalism option, and that kind of thing. So I agree with you. That is a very positive sign, and I think that underscores that we were taking the right approach at the last meeting. Any other comments in that vein? Well, if not, you'll see in the agenda item 6 that we're giving Cameron a little breathing room. He's got a very important and intense trial coming up, and we've given him back to Catherine to work on that for this meeting. And I think in the August meeting, we'll have to trade. We'll have Cameron, and Savannah's got one of her own at that time. Anyhow, getting to item 7, which is what I want to spend the rest of the time on that we have. This picks up where we left off. If you turned over to page 2, you'll see at the top of the page is something called Chair's Notes. These are my notes from our last discussions, collapsed, made simplified. Not everything is in there, but I thought items of that were being of some importance are just summarized basically. So you get an idea about the flow of our discussions and where we got to. Where we got to is over on page 5 in this abstract of Rule 26. We got through, I believe it was B1, and I think that's where we were with Shelley commenting at the end that great to have a grand tour, but 20 days should accommodate it, or words to that effect. Thank you, Shelley. Now, is there any, as we look, we see here B2, which is the next part of that abstract, talks about 12 weeks for birth, adoption of child. Is there any comment on that rule and whether it's inclusive enough? One of the earlier comments, and I think that may have been made by Dion or Catherine. What about children? What about spouses? What about elderly parents? And that kind of thing. There are very adequate. Well, I'm not saying it's very adequate, but at least there is a 12-week set aside for birth, adoption of a child. I don't know about whether that should be extended for caregiving to spouses and immediate family, whether that should be the subject of another study or what. But before we pass over to, I'd like to see if there's anyone who wants to stay a while in that topic area and talk about it.
I would
you're a good builder.
I would add to this that my feeling has always been that secured leave was primarily for vacation time to get away from the practice. If you're talking about the birth of a child, a sick spouse, elderly parents with medical issues, I'm not sure I like secured leave applying to that. I think that something maybe should be in our conclusion that if somebody has a medical need or a medical situation, I think a trial judge should be in a position to grant them whatever a medical doctor or someone looking at the situation could determine as to how many days they would need to be in a caregiving situation. I view the secured leave and caregiving as two different things. And I'd hate for somebody not to be able to give the care to a new baby or a spouse or an elderly parent because of the rule. I think a judge should have some discretion in that.
Okay. And that's, Mel, that's very consistent with the position you were taking at our last meeting, that it's different and
Yes.
should be different.
Yes, I think so.
Is there any thought that the provisions with respect to time off for life events, as opposed to a focus on vacation, could be in its own rule, or just leave it alone for now?
Well, I think you'd have to put some guidelines as far as that's concerned. We don't want somebody to have the right to decide, okay, I've got a sick child, I've got a sick wife, I'm going to take a month off. I think you'd need to have a doctor's excuse or reasons given by a doctor as to why that person should not be in the practice for it. I think you bring a medical opinion into it that way.
Should we, as we work the secure leave rules, is when you talk about medical, or you talk about transitions, life care kind of things, should that be dealt with by making a recommendation to the issues committee to form a subcommittee to look at that specifically, and take the position that we're looking at secure leave as we believe it was intended to be, and not looking at the other possibilities, because there'll be other provisions that we'll be getting to otherwise. What do folks think about that?
Do you?
Well, go ahead, Savannah.
I was going to ask Mel if he thought that his or that the scenario that he was describing, if it's a sick spouse or a sick child, that going to that court for permission would just fall under the current subsection H, which it doesn't limit, the power of the courts or of our judges to allow some leave that's not secure leave, but doesn't just limit it to, caring.
I'm with Mel. I think we need to keep this pretty limited. I think that the scope of the rule goes about as far as I'd like to see us go right now, because as it is, it's really an honor system. It's self-affecting. And I don't think we want to get in the business of requiring some kind of doctor's notice or any kind of judgment to be exercised by some third party to determine whether somebody's properly taken leave or not. I mean, you've got whatever the amount of leave is, and you can take it for any reason or no reason, and just make sure that we continue to recognize that subsection H is there for extraordinary circumstances. And that does, I know one way to look at it is, well, that's just one judge in one district would grant that kind of extraordinary relief, but what judge is going to overrule that or not go along and accept that? If you've got your local resident superior court judge who's granted you some additional leave for extraordinary reasons in your district, what other judge in another district is going to say, I'm not going to honor that? I mean, this is the real world. I don't think we have to assume a lack of good faith on the part of anybody in this process. I think we've got, there are just so many extraordinary kind of circumstances that can come up. We can't possibly foresee them, but the rule allows room for that as it's written now.
Good. Shelley, do you have an opinion? trying to find her mute button. I'll pass that along to Mark. Mark, what do you think?
I agree. I agree that we've got that special category. I would not try to change that portion of the secured leave rule. So I think I'm on the same page.
Okay.
I'm on the same page too. Sorry about that. I mean, I think it's important that there be opportunities to take more extended leave in scenarios where it's called for, but I think that's a separate question, really.
Okay. All right. With that much said, then we won't dwell on subsection 2 any longer. Instead, let's go to D, content of designation, and then deal with it, because based on our conversation last meeting, well, this will have to be conformed. The period runs Sunday to Saturday. Obviously, if we end up recommending a minimum of a 2-day block, then Sunday to Saturday is no longer going to be the rule. What do you think we should do?
And I do think we should amend the week. I think we amend the week period so this becomes moot.
Okay. And there's a question after that period runs Sunday, Saturday. I agree that's no longer holding. What happens if there is a court holiday in the week? So here's the point. With any week, there was likely to be a holiday, either a court holiday or a federal holiday or a state holiday involved. If someone picks a date or picks a 2-day block, or say a 3-day block, and in the middle of the 3-day block there is a court holiday, then in that instance, is it just to count against them for 2 days, or will it count as 3 days? What I'm potentially advocating for is the rule that it's a 2 business day block. Because there's not going to be on a court holiday any business to transact. And if we're thinking about trying to be as careful as possible to preserve the maximum number of days within reason for attorneys to have, there's just so many times that they can sometimes get 3 days for 2, 4 days for 2. It may be a better thing to have. And I'll open discussion on that.
I'm fine with the 2 days for 2. That I don't know that anyone should be penalized for there being a court holiday as well. But I am kind of concerned about a maximum number of opportunities to take leave. I mean, I think if you're, taking leave almost every month for 2 days, that can get cumbersome and sort of distracting. I think maybe limiting it to something like 6 or 8 a year, no more than 2 a quarter, something along those lines might be wise, but those are just my thoughts.
Okay. Going back to the straddle situation we had, we discussed last time and the decision, I think the group decision was charge the day taken for whatever year it occurs in. If you end up with a situation like taking off you want to take off the last day of December and January 1, and then use January 2 as a travel day, assuming none of those run on the weekends, then you've got a situation where you should be charged in current year for the December 31. You've got a court holiday on the 1st, if it's during the week, and then be charged for in the new year for January 2, because normally the courts don't take that off unless there's a weekend involved. So, you know, we're getting into almost computational issues here, but there are going to be people that are going to be asking these questions if we don't settle them. So I think we do have to deal with what happens when there's a holiday. As it stands now, with a 2-day minimum block, and assuming we go to 20 days, 20 weekdays, rather than deal with weekends. So we've got a total of 20 possible weekdays of secure leave. That would be a maximum of 12 opportunities per year. What did I say? 12? It'd be 10 opportunities per year. Sorry. And is that too many? That's not one per month necessarily, but it would be over a course of 10 months. That could be that much taken. So, what do you want if the rule is changed from weekly to a minimum of 2 days? What do we tell people in terms of the computational side of things? Walter?
Being from Anson County, Gordon, I like to keep it as simple as possible. And I would just like to leave it that you've got, a maximum of 10 opportunities and 20 total business days or court days, however we need to define that term. I'm looking at the way the current rule reads about going from one calendar year to another, and it seems to me that would be okay as well. That it all counts in the prior year. If it goes over the Christmas, goes over the New Year holiday. So I'm all in favor of keeping it simple and not making people spread it out or anything, unless and until we find some abuse. And if we do, then I think we need to take another look at it.
Yeah. Any other thoughts? I will say, Walter, I thought my notes may be wrong on this, but it's I thought there was some agreement last year that we were going to, last month, that we would straddle by whatever day you took would count in the year in which it was actually taken. So in a situation where you're taking a holiday over the Christmas break and straddle the year, those days that are in the first year will be attributed to that, and those days that are in the next year would be attributed to that. Does anyone else have a different memory?
Yeah, no, I think that's right. And I think I was advocating for that view. I actually think that may be simpler. I mean, I agree with simplicity. I was just thinking, it was more of an issue when it was a full week and figuring out how to count it. If you're doing 2-day increments, I guess it may be simplest to just not worry about any different rule for the end of the year. And you just, if you take 5 days and 2 of them are in 21 and 2 of them are in, and 3 of them are in 22, you just count them that way. So I think that's easier. I don't feel super strongly about it. I guess the argument to keep it the way it is people are kind of used to that carryover rule. And so is the difference more difficult? I don't feel strongly about it, but I guess to me, with the smaller increments, it's easier to just say they accrue in the year that they occur in.
Yeah, and we did decide, I think, everybody felt strongly that we shouldn't have accumulation. And the straddle rule as it exists today is a reverse form of accumulation. It accumulates all in the prior year. So
I guess the only technical Gordon, the only technical question is in your example, if you're taking January 2nd off and that's the first business day of the new year, do you have to take 2 days in that year?
Well, that's the technical issue. If the intervening day or days are non-court days, then what you've got are 2 consecutive business days.
But they're not in the same year.
They're not in the same year, but I don't know whether the focus should be on it being something that's mapped out by the year. What the year serves for is the maximum is a period for the allowance to be taken that starts on a day certain, ends on a day certain. If you use the straddle rule as it exists today, it's going to start on a day certain and could end well over into the new year. So I think there's probably more certainty about being hard on what a December 31, January 1 transition looks like. And when you get to holidays, the court holidays, would it be prejudicial to the courts to allow someone to take their block in consecutive business days? That's the thing we didn't discuss last month is, okay, so are there going to be business days? We're certainly not going to talk about weekends. We've been talking about 5-day increments all along. And I'm amenable. I mean, I'm the weak link in this group. So what you folks think ought to make the best policy, I'm going to be 100% for. But we've got to provide something that I think supports efficiency and utilization of secure leave, decrease the amount of time for lost days simply because of the way the calendar falls. And that's sometimes when you have travel time around holidays. And you've also got to give something to folks that is can be counted clearly and be within their understanding. I just otherwise it's not going to be doing its job. So all those competing considerations, what should be the rule? I think we can, sum it up. If we do decide that straddle rule is you account for your use of the secure leave day in the year in which it's actually taken, not from where it may have started, then you've certainly got, you're always going to have your 20-day limit year to year. And there's no reverse accumulation. There's no carryover. It's just that. on the question of whether what you get is what you have to do is a minimum of a 2-day block, what happens if you're going to count that on consecutive calendar days, or you're going to count it on the basis of business days? It'll also come into play if you want to take off a Friday and go to a Monday and take off one there. You're looking at 2 days. They're not consecutive unless you just count business days. But what about long weekends? What about holidays that end on Mondays or begin on Fridays? There's a lot of opportunity there to deal with pure leave as we most commonly believe it should be, which is for vacations, recharging batteries, and doing things like that, that can come into play. And anytime you're dealing with a split with an intervening weekend, I mean, what can you do? The old rule never concerned itself with that because it went from Sunday to Saturday. But you only got 5 days for that so-called 7. I guess that's how they solved the problem. Mel, do you think from a policy standpoint and from what the court system would be willing to tolerate, whether we're possibly going too far with this rule? I don't know.
Well, my only concern as I listen to the discussion is whether or not somebody who, for example, has had a problem with a particular judge who may be assigned for 6 months handling, we'll just say, domestic case. And this person is able to take 2 days for 10 months during the year and avoids that judge throughout that 6-month period of time by taking 2 months. And let's say that domestic cases are heard Tuesday and Wednesday or whatever. I would just be a little bit concerned about somebody using it in that way to avoid a situation. But I can't imagine anybody taking 10 2-day vacations anyway. But I do think, I just don't want to see it written in such a way that somebody can abuse the system, if you will, by dodging somebody. That's not my idea of what the secured leave was for. But lawyers are creative, and I guess if we do it that way, we need to give some thought to what may occur. But that's my only concern.
Okay. All right. Mark.
I don't have a lot to add. I mean, I think I agree with Mel.
All right. Shelley.
I don't have anything more to add.
Walter.
Again, simplicity probably is the best route. And so if we're just talking business days, consecutive business days, that makes it simple. And it gives people maximum flexibility to use this secure leave for the purpose that it was created. That is to give people a break. Longer week, we got a lot of staff who take a Monday and a Friday and a Monday off so that they can go somewhere and see family or whatever. I think that flexibility is good.
What's the sense of the group then on what we should do in terms of the computational aspect of the rule? You know, there's always that concern for abuse, and I hope we're not bringing Pandora's box to the judicial system with some of our work. But what do we say? I'm an advocate for the 2 consecutive business days because I think they're easy to track. Grant you, once we went from weekly to 2-day minimums, we may have created a more of an opportunity for some abuse. We just don't know whether that will happen. The data from the survey tends to suggest it might not, but you know, people are lawyers because they're bright and crafty. So we'll find out down the road. But I think for be able to go forward and continue our provision by provision review, we've got to resolve this hopefully today, and when we get some more get some of our members back and see if they agree with us before we start writing this thing up. Maybe I should do this. Let me just get a sense. Is there anyone that's opposed to the 2 consecutive business day solution, and would prefer saying if you take a 2-day block, then you know you've got to count. If that second day, the following day is a state holiday, then you know that's tough darts. You've got you know you that counts against it. You know that's a little uneven, even in that example. But what do you think? Let me pick on Mel again. Mel, help.
Well, when you say 2 consecutive days,
Business days.
2 consecutive business days, are you saying that they could do a Friday and a Monday?
Yes.
Okay. Well, if the committee votes in favor of that, I'm in favor of it. I don't want us to be in a situation where we allow somebody to abuse the system. And I don't, as far as I know, nobody's ever abused the system. And I just don't want us to be in a situation where somebody can abuse.
Shelley?
Yes, sir.
Are you on board? You on board with that?
I'm on board with that. I mean, I don't think you should be penalized by taking a holiday near a state holiday and have to be assessed that court holiday along with the ones that you've taken. And similarly, I'm okay with if it's a Friday and a Monday, with just having those count for 2 towards the total, if I'm understanding the calculation correctly.
Yeah.
And I guess I should also say my concern is not so much some sort of intentional abuse of it. It's just how it might affect court proceedings to go from, I guess, a maximum of 2 to up to 10 under this new 2-day system that individuals might be seeking secured leave.
Correct. Right. And I understand and respect that. I think that it's not only concerning to Mel, but we don't know where that may go.
Right.
But hopefully from the general philosophy we brought from last month's meeting, we're not going to let that that concern define us, but it doesn't mean we're going to ignore the possibility either. We'll just have to see. And if it turns out to be abuse, it'll be an abuse generator. I think there'll be another subcommittee.
And I agree with that. I think that's the way to look at it. We do the best we can, and if it turns out somebody's playing the system wrongly, then we have another subcommittee and change the rule.
Right. And it's not just whether somebody's playing the system, it's whether the system can support it too. I mean, just how that affects court scheduling.
Yeah.
And disposition of cases.
Walter? Correct. Walter, you on board?
I'm on board.
I'm on board as well.
Okay. Next quick question. I think in the example that I give, it's following state judicial holidays, which can be at variance with the federal holidays at times. Think of, although they try to make them coincide. You think for policy purposes, since we're concerned about the courts, and we don't want to get in a situation where we're in session when there may be another holiday out there that's not observed by our state judicial system. Should we use that as our defining what is a business day and what is not, either weekends and state judicial holidays?
Yeah, I think that makes sense. We're protecting them from court, so
Okay.
if it's an official holiday, they don't need it to, that wouldn't count.
Okay. Great. So we've done two really big things today. We've dealt with some not purely medical issues, and making sure that we leave 26H up, for that kind of thing, and I think that's well done. And now we've got our computational basics in front of us. We have used up our hour, and I'm sorry about the communication problems in the beginning. I think that when we have our meeting in July, my goal is to get through the next few steps of Rule 26. I think maybe one of the more controversial ones will be F1, the 90 days before secure leave period begins, and before a conflicting proceeding is scheduled, and then particular provisions for the depositions. We also need to look carefully at the appellate rules and see if there's how anything we're doing in this corresponds to those rules or not. And so we've got we'll have a lot on our plate at the July meeting. So we may see if we can allow a little more time for that, maybe an hour and a half to get that done. I would very much like to be in a position to showcase your work for the Issues Committee when that report is given in Asheville. I can't tell you how pleased I am with the way you all have dealt with this on a very intelligent policy basis for what you're doing, and I think it will be well received. Certainly, we're starting to get those comments in on the surveys from the show that this is a matter that people will be willing to respond to and comment on. So that's the game plan. Is there anything else that you would like to do today before we adjourn?
Gordon, there's not anything else that I'd like to do today. I think we've gotten a lot accomplished. One thing that the survey reflects an interest in is the simplification of the filing, and I don't want to lose track of that. I'm hoping there's a technology solution to that, so we could have statewide filing. But I don't know that anybody's specifically looking into the technology side of that and what may be possible. You know, given we're going to this, eventually going to this statewide filing system, and so, you know, I think that's something that's going to take some homework to see if there is a simple solution there.
Right.
I think that's a very good point. What, as I said earlier, one of the complaints somebody had was that they had 50 cases that they had to send out notice on. And I agree with Walter. I think we ought to be able to simplify that.
Yeah. That can be a time saver. Is it your understanding that all this technology is going in statewide in a short time frame? I'm behind on it.
Yeah, well, it's going into Wake County as soon as they can sort of get it up and going, and it's going to be phased in across the state over a period of a few years. So we're not looking at something that's imminent. But we already have this courts.com website that has statewide calendars. And it would seem to me that there may be some solution there that's worth at least exploring.
Okay.
nccourts.com, I'm sorry, which statewide calendars, and you know, they don't mail out calendars anymore, as we all know. You have to go there and look if you have something pending in a certain county. You got to go look for it. And I guess there's some notification system too. I don't know how it works. Fortunately, I have people smarter than me here who keep me out of trouble.
But Walter, you're talking about trying to think through the possibilities. You could have a statewide registration for secure leave. And
yeah, you just log on like you do. Yeah, log on like you do with the appellate court, and just put it in.
Well, the problem with you, my poor and now long-suffering members of this subcommittee, has got a chair that can't even get into a Zoom call. I think it's time for me to delegate. Tag, you're it.
Well, I'll be glad to look at it. I'll be glad to do some checking around on that if somebody hadn't already done that. Savannah, have you started that?
I have taken the COE and registered for e-filing in Wake County. And my understanding is that it will at least be helpful in serving your notice to all of your opposing counsels in the court. Some of the comments that we received was it's an administrative hassle for lawyers who have 50+ cases to print all of those notices, put a cover letter on it, and mail it out. E-filing is definitely going to make that part easier. I don't know that anyone has thought through what the process would be, but I know that just serving documents on any lawyer who is also registered for e-filing is going to make that easier.
Yeah, I'm thinking about something even simpler than that. There's a statewide portal, just like there is filing in the appellate court, where it's just a secure leave portal, and that would come up anytime anybody checks for secure leave. I don't know how the different counties keep track of it. It must be a nightmare.
Right.
Yeah, it's got to be. Let me say that there may be since everything's supposed to be in the public domain anyway, but the information is disassembled. Maybe this shows my age, but I've always been hesitant to put it out there, even though I've had to. But if I put something in the public domain where they know that I'm taking 2 weeks off, I'm thinking that's when the bandits are the wet bandits are gonna come to Kevin McAllister's house and break in.
Yeah, yeah.
Because you're telling people you're going to be gone, or you're at least supposed to be gone, and so that's and I don't know how people deal with that, but I've always been very concerned about it, and concerned enough that at least I'll ask the sheriff to drive by, or somebody I know and trust to come and see the house every day. But it's a real concern for me. But I don't know how you do it otherwise, because the rules now are it's got to be, you send it in, it's public. But the information, the data is so atomized and scrambled in only in pockets of different places that somebody that's an evildoer probably is not going to go to the trouble of checking that out in a small county like I'm from. Anyway, anyhow, I think it would maybe something that we could get to. I mean, I think Walter knows a little bit about cybersecurity, don't you, Walter?
Oh, I'm trying to learn, Gordon. I'm slow on that. I'm trying to learn. So let me just make some preliminary inquiries about that with folks.
Okay.
And I'll report back next time we get together on what I've learned just on the surface.
Okay, very good. Well, I'll go ahead and put you on the agenda unless you call me off and wave me off, and we'll reconvene sometime the week after the 4th, unless some of you all are on secure leave, but maybe you can patch in from wherever you are.
Gordon, before we get off, do you want to entertain a vote for the minutes of the May meeting?
Are you all with your calendars right now?
She's talking about the minutes of the past meeting.
I move to approve the minutes.
I'm sorry. I misheard that. Yeah.
Second.
The rush to get started. I did overlook that, because we have the draft minutes that appear on pages 8 and 9 of the agenda. And if you've had a chance to look at it, good. Does anyone have any amendments they wish to suggest, or any items that need to be corrected? If not, I'll entertain a motion to approve the minutes.
Second.
All right. All in favor, say aye.
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 Aye. Okay. Any lonesome polecat saying nay? Nope. So minutes are approved. All righty, folks. Well, look, your efforts are much appreciated, and we'll reconvene hopefully a week after July 4th, and we'll have something that everyone can be proud of when it's submitted to the issues committee. Thanks.
Thank you.
With that, we will adjourn.